Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Jaclyn Phillips, and the title of today's episode is Has a New Ecosystem Been Discovered? The European Commission Blocks Booking's Proposed Acquisition of eTraveli. I have no doubt that most, if not all, of our listeners have used an online travel agency to help them identify flights or hotels for an upcoming trip. You may have even used Booking for your hotel and eTraveli for flights. Today, we're going to discuss the EC's rationale for its decision to block Booking's €1.6 billion acquisition of eTraveli, even though there's no horizontal or vertical relationship between Booking, used for hotels, and eTraveli, used for flights. In a first-of-its-kind decision, the EC determined that ecosystem concerns were sufficient to block the deal. In short, that the deal would enable Booking to increase customer traffic to the Booking ecosystem, enabling it to benefit from network effects and strengthen Booking's dominant position on the market for hotel online travel agencies. This unprecedented outcome leads to many interesting questions and implications. And as of the date of this recording, November 2023, Booking has announced that it will appeal the EC's decision. Here to help us dissect the EC's decision is my co-host, Matthew Hall. Hey, Matthew.
Hi, Jaclyn.
Can you please introduce us to our guest for today?
Our guest today is Eliana Garces. Eliana is a senior advisor with Analysis Group based in Brussels and Washington, D.C. She has previously worked at the European Commission's Directorate General for Competition, or DG Comp, in the Chief Economist's team, and also in Commissioner Almunia's cabinet. Her consulting and casework experience includes mergers and conduct cases in a range of sectors. She's published extensively on topics including the antitrust analysis of commercial practices, the assessment of conglomerate mergers, value creation processes in platform businesses, and behavioral economics. She is a co-author of the widely used book, Quantitative Techniques for Competition and Antitrust Analysis. Hello, Eliana.
Hello, Matthew. Thank you for having me.
Thank you very much for coming on the podcast today. As Jaclyn mentioned, the European Commission looked at various issues, including ecosystem concerns. Can you take us through what exactly the Commission means, or we think it means, by ecosystem concerns?
So the Booking eTraveli decision is really interesting and very policy setting. It is the first merger prohibition based on an explicit ecosystem theory of harm. We've known for a long time the Commission and several regulators in Europe had expressed concerns about large platforms, which they consider dominant in a core service, expanding to new services. There was a lot of commentary around the fact that this expansion could be detrimental to competition in various markets. So this is the case that for the first time tells us how those concerns get implemented in an assessment and can go to a prohibition decision, as in this case. So the interesting part here is that the theory of harm addresses a strengthening of dominance position in the core market. So we don't have the typical theory of harm you would expect in a non-horizontal merger, which would be the leveraging of dominance in a market into a new market. So an expansion of the remit of the dominance. Here we have actually the acquisition helping reinforce the existing dominance of the core market. And in particular, the eTraveli, so the acquired entity, which is not considered dominant in its space, and that's the other interesting part. Although it facilitates dominant, and it is not in itself dominant. It's just considered a best-in-class operator in the flight service. but it is considered to be an important channel of customer acquisition for Booking. And so through that channel helps reinforce Booking's dominance of its core market and then by extension its ecosystem. We've seen this concept before in Amazon MGM, Apple Shazam, where the Commission had already assessed whether an acquired service would help acquire new customers, but it was never given that much of an importance. It was never considered an element with a material impact. So this is the first time that this acquisition of customer becomes important enough to lead to the blocking of an acquisition.
I think it's been reported to be controversial even within the European Commission itself, and it seems to arguably go beyond what's in the existing non-horizontal merger guidelines which the Commission has put out, and can be based directly on the merger regulation itself, the basic text. But let's look at this concept of customer acquisition channel. This was clearly, as you say, a key issue here. How should platforms look at this issue, and how was it looked at in this case, the concept of a customer acquisition channel?
So I think it's important to go back to how European regulators and the Commission and the policy documents that Commissions has commissioned, how they defined ecosystem. And they define ecosystems as systems of several products where these products are linked or interlinked either through the supply side or the demand side. But that means when a new product arrives, through those interlinkages, they affect all the other products. And we've seen some implementation of that in conduct cases and arguments that establish the supply side linkages through data, for example, the acquisition of, for example, if you think of Google Feedback, that the acquisition of a new service provides new data and how that new data could affect the provision or the quality of all the other services. So that in itself, we see already a linkage on the supply side. Now, this case in Booking eTraveli, we see the establishment of a linkage on the demand side. And we've already also heard about such linkages when we talk about network effects and indirect network effects, and how the arrival of new users may generate demand on another side or another product. But here the case, it relies to a certain extent on network effects, but it relies on a demand side linkages that basically says if Booking acquires eTraveli, the users of eTraveli will end up on the Booking ecosystem generating new demand for Booking's core business, so hotels or potentially other complementary services. And so it's that linkage that is very interesting. The Commission based it on what they call customer inertia. So once the customer arrives on Booking ecosystem, in this case through eTraveli, the customer is going to stay there. But how did the Commission assess that? Well, that's a good question. I think they did say to look at the relevance of that phenomena. They look at how complementary the two services were. So how likely are people buying flights to buy hotel? Are those two markets very complementary? So the second thing they looked at is what is the importance of customers buying flights to the hotel demand? So how is that channel important to, how much is that channel important to Booking? But ultimately, so it's what is the capacity of a flight selling service of generating demand for a hotel flying service. But because people are not tied in the ecosystem, once they're on Booking, they're free to go and buy hotels wherever they want. The Commissioner added this element of customer inertia. Once they're on the ecosystem, they will stay on the ecosystem, and that's a key element, I think, in the assessment of this case.
It's interesting to note that the UK CMA appeared to reach a different view in clearing the transaction in relation to customer inertia. Why do you think that is, so far as we can tell, in relation to the difference between the UK and the European Commission finding on that point?
Well, I think it's the assessment of the strength of the effect, and I'm thinking also the evidentiary standards that you would have to meet to show and establish that inertia. I mean, it is a very behavioral theory of harm in that sense. You would want to know, for example, so you there's a very factual question: is how many people who buy flights actually buy hotels? That companies can give you that data. But is this enough to decrease the contestability in that market? How many customers would you have to attract to really decrease the level of the contestability of the hotel booking flight overall? And there, the benchmark, I think it's not that clear. It's how many customers are you going to get through that website that will actually convert on the platform, and is that going to foreclose the market? And then there's the issue also about why are customers choosing the hotels if they buy on Booking? Are they doing that because they like the service better? Do they like the convenience? One would want to understand the parameters of that choice before calling it inertia and maybe labeling it as problematic. So I would say the evidentiary standards would have to be met to exclude a case of an actually efficient and positive choice for consumers.
Absolutely, and as you know, there's a lot of discussion in the EU and the UK about a so-called efficiency offence. It is in theory possible to defend mergers on the basis of efficiencies, but that could bleed very quickly into a so-called efficiency offence. How was that looked at by the Commission, so far as we can tell, in its analysis?
So I think that's the big question mark. I think here the efficiency discussion seems to have been put on the side. One can imagine that having many services conveniently supplied together is efficient for consumers. It eliminates a lot of the frictions in the transaction. It may save time. It allows to stay into the flow of the transaction. But because you have to keep in mind, consumers are not tied, so they are free to go and buy hotel bookings on any other website of their choice. To what extent can you discard the efficiencies of this design? I think is a question, but it's a legitimate question. And we know in merger assessment, efficiencies are part of the assessment, so you can't just set them aside. And I think it goes back to the question of, are we really understanding consumer behavior? Are we putting the effort to understand the user behavior in this case? But I would think that is a question mark over this whole decision. Are we not paying sufficient attention to the efficiencies of facilitating a flow of transactions to users?
And following up on that, and also for our listeners in the US or companies who are looking at doing transactions in the US, do you have any views on how the EC's decision and analysis comports with the US view of things? What can we learn, if anything, about this theory and how it would be applied elsewhere?
So I think the US agencies have demonstrated, I think, also a concern around quote-unquote ecosystem expansion. It was a bit present in the Microsoft Activision investigation. also in the Meta within merger investigation, there were insinuations that Meta wanted to strengthen its overall ecosystem and raise barriers to entry for competitors. You see elements of ecosystem theories even in conduct cases. In the latest Amazon complaint, they talk about feedback loops between relevant markets, although they rely only on network effects rather than behavioral assumptions. So I think there is a potentially a willingness of U.S. regulators to push or test that direction than in Europe to brush over efficiency considerations. My guess is that the evidentiary standards to show the mechanism in play, but also to demonstrate harm would be higher. They would be higher to me in the U.S. So I think those definitely, and a case like Booking, I think would be much harder to run in the U.S. It's my personal opinion, at least.
Yeah, and I think it's interesting to look beyond this case. Of course, all cases depend on their facts, and here the Commission found that Booking had a share in the EEA and hotel OTA, online travel agents, of over 60%, 60, with only one other sizable competitor, mainly focused on the US. So clearly a very important player. Therefore, may be easier to find that it strengthened its position with this proposed acquisition. But it seems that these ecosystem cases will probably be more common in the future. I'm thinking, for example, that you're getting a lot of technology now with effectively unlimited use cases when you have generative AI or virtual reality. Seems that these could raise ecosystem concerns. So what are your thoughts on how in we should think about competitive dynamics more generally in ecosystem type cases, and what arguments and assessment would be relevant?
Yeah, I think a lot of these theories will depend fundamentally of the assessment of what the Commission has called, or regulators have called, the entrenchment. So there is, at least among European regulators, there is this presumption that once a big digital company acquires dominance in a particular service, that they become entrenched due to the characteristics of digital production and distribution, economies of scale, network effects, the power of data. And so there's this very strong presumption that's what, once you get to that size and importance in the market, is going to be very, very difficult to displace you. And the assumption is that then the company or the platforms just goes around what they refer as building moats around your core service to further protect that dominance. And I think that vision of how the digital space works is what drives, I think, a lot of the assessment. And so the real question is, to what extent is this entrenchment real over time? The digital space, we know, is dynamic. We know entry can happen and actually a lot of the significant entry happens not by people replicating your business model or your core service, but by people or companies specializing in another service and suddenly invading your space. So they're lateral entries, if you want. And so to what extent that is being taken into account, to what extent it's happening, to what extent would that be successful, I think it's something that will need possibly more scrutiny. And companies that feel that they are responding to the market evolution and responding to potentially an evolution in user preferences or threats from other business models or players coming in, I think we'll have to put a lot of effort in demonstrating that that in fact they are evolving in a pro-competitive way as opposed to entrenching their dominance of the core service. But I think that's a topic or a dimension that hasn't been fully explored yet.
Of course, the Commission found problems in this case, but that's not the end of the story. The booking tried to escape, as it of course can, by offering remedies to deal with the problem. Here it offered, and I appreciate this is less economics and more kind of commercial work possibly, but Booking proposed to show customers a choice screen on the flight checkout page, so after they'd chosen the flight, following the merger completing. And then on that checkout screen, Booking offered to display multiple hotel offers from itself and competing hotel OTAs, so in theory allowing its competitors access to those customers as they were exiting or having made their flight choice. Amongst other things, that would have been powered by Kayak, which is Booking's meta search service, which crawls the web looking for hotel alternatives. Olivier Gerson, the Director General of DG Comp, after the rejection of the proposed remedies and therefore the blocking of the transaction, said, quotes, "The Commission should never accept this type of remedy," end quote. What are your thoughts on this proposal by Booking and its whether it should have been accepted or not?
Well, I mean, we don't know the details of the remedies and the conversation, but prima facie, the ballot choice, in a way, has been a remedy of choice for the European Commission before. So we've seen it in the Microsoft browser case, we saw it in the Google Shopping case, and so it doesn't feel like a far off remedy. It actually, at first sight, it seems a perfectly reasonable one to offer options at the point of checkout when the decision is most likely to happen to go into the next stage of the booking flow. So one concern of the Commission was the bias. So because it was going to be operated by Kayak, which was a first party, it was owned by Booking, it may not have been completely neutral. Which also is surprising, given that we know in other spaces, like in the implementation of the DMA, for example, the companies are expected to run those choice screens and the choice pattern for users. But in this case, for some reason, it was considered unacceptable. The most interesting part, though, was we know the Commission said it wasn't sufficient because it offered choice only at the time of checkout, and there would be more opportunities in the communication with customers for Booking to advertise the hotels, its hotel services in the context of the booking of flights. And I think one can think of emails or promotions or just any form of communication. This is, to me, what this means is that the Commission was looking for almost like a complete siloing of the two businesses. So any cross-selling, any cross presentation would have been was effectively seems to have been frowned upon, and so. So what that means, I think, is like if in similar acquisitions, companies will have to almost from the starting point presume that the Commission may want to silo those two businesses and then start a conversation about, okay, what are the permitted linkages that we can build across the two products or services if we acquire them? How can we connect them, if at all, within our business? And I think that's going to be the discussion. And at this point, there's very few hints about about how that conversation would go or how that would be assessed. But we do know that the Commission says, okay, is it going to drive more users towards your core platform service and towards your core business? That's what the Commission will be looking at.
That siloing would seem quite difficult because it really would amount to a kind of indefinite hold separate, a kind of regulatory split like you might find in, I don't know, telecoms infrastructure or something like that, and probably get rid of any synergies in most cases. Right. Finally, on the substance, Eliana, Booking has already said that it will appeal. In relation to economics issues, what do you see as the areas that you think you would, from the outside, be focusing on here?
Yeah, so I think there's, I would say there's one fundamental one and maybe three others that are more classic. The fundamental one is at the core of this theory of harm is a negative assessment of those interlinkages, is the fact that any new acquisition will be almost exclusively assessed as to whether it reinforces the core service and the ecosystem as a whole. And I think that that reasoning of you're not allowed to make your ecosystem stronger is I think that there's going to be a lot more detail asked of the Commission as to why, as to how that works, and why is that always a problem? Why is that necessarily a problem? Given that you're acquiring a service that is not in itself dominant or occupying another market. So I would say at the core of this question is, at the core of the debate is the fact that the Commission is deviating from its traditional assessment of leveraging dominant position into another market, and is using the acquisition of a market, of a business that is not dominant, to build a theory about how that reinforces dominant in its core market. And the mechanism of that, I think, possibly needs to be better established and further substantiated by the Commission. And I would imagine that many questions around that will be asked. And then more traditionally, I think there's the assessment of efficiencies. I wonder whether parties will ask whether they were sufficiently assessed, the standard of evidence, whether that was sufficiently met, or is the case built mostly on a presumption? And then there's the if the company submitted evidence of competitive threats of dynamic evolution of the markets, I would expect that would be something they would want properly looked at by the Commission.
Thanks so much, Eliana, and getting your views on this new theory is, I think, important for all of us and truly helpful kind of figuring out what the EC was thinking kind of going down this road. So before we let you go, we want to hear a little bit more about you. So our first question that we ask all our guests, can you tell us something about yourself that we wouldn't know if we only knew you in a professional setting?
Okay. I can talk a little bit about some of my hobbies. I like trekking, and recently I've also started running. So I run 5Ks, and I mysteriously found out that I actually really like it. And this summer I trekked the Salcantay trek in Peru for 10 days, and again I immensely enjoyed it, although the altitude was harsh. So I that's pretty the way I love trekking and running. I'm not particularly great at it, but I really, really enjoy it.
That's awesome. Well, if you can do that trek in Peru, I imagine a 5K is really no big deal for you. So I'm glad you've found some fun in running. And then we will go to our last segment.
And now it's time for the Curious Hat!
All right, so we call this our Curious Hat, and I'm going to ask you a question from our virtual hat. If you were given $50,000 on the condition that you had to spend it all in 1 hour, what would you buy?
Oh my God, $50,000? Well, I don't have anything on my shopping list right now for that amount. I think if I only had 1 hour to spend it, like if I've given it to now and I have 1 hour to spend it, because I think I lack imagination for that kind of purchase, like I think I would give it now to like an education scholarship or something, because I don't think I could come up with something within an hour that would make sense for myself. If I had more than an hour, that the reply might be different, but within an hour, I think I'll donate it for education, for a scholarship for at least one person.
Well, that's awesome, and I'm sure that mystery person would appreciate your imaginary $50,000 for their scholarship. So thank you so much, Eliana. I have found this extremely enlightening, and I'm sure our listeners will too. So thank you, and thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.